So good morning, everyone, and welcome to Australia's Earth Laws Alliance Earth Laws Month webinar for today, September the 8th. Well, actually, it's September the 8th here in Australia, but I think it's still the 7th where our wonderful guest speakers are joining us from. The time-space continuum is a constant surprise to me. But I'm so delighted you can join us. I'm really pleased to be able to introduce Margil and Thomas Linzey from CDER, the Centre for Democratic and Environmental Rights. In a moment, I'll introduce them more properly and gush just a little bit because they are some heroes of mine in the pioneering work that they've done. But first, I'd like to acknowledge country. I'd like to acknowledge that I live, work and play here in the beautiful traditional lands of the Yagara and Turrbal peoples, First Peoples of Australia. I'd like to acknowledge elders past, present and emerging, and the remarkable civilizational culture that these peoples have had since time immemorial. And despite the disruptions and often the horror of colonisation, the remarkable resilience of Aboriginal peoples and their laws continues to inspire me. I also always like to acknowledge the ongoing impacts and legacy of colonisation in Australia. The work we do, particularly around the legal element of AELA's work, connects very deeply by challenging what are the best and most fit laws for a continent such as Australia. And, you know, some people rattle off 60,000 years, other people say since time immemorial, but the remarkable governance system that Aboriginal people built and have and continue to have today is a huge inspiration for AELA. And I hope that if you haven't already seen our program for Earth Laws Month throughout September, please do have a look, and I'll be popping the links in later. We've got some really wonderful Indigenous speakers throughout the month talking about their own legal systems and their own governance. So that's a very long acknowledgement of country, but this work is so important to me. And I think many of you know I work with a remarkable number of, well, a number of remarkable elders, including Mary Graham, and we're working on a book together looking at what the relationist ethos would look like in the modern Australian context. So it is very important to all of us. And in that respect, the rights of nature movement has offered some very interesting ways to spearhead different conversations in countries like Australia, really challenge Western law and really challenge these notions that nature is nothing but human property. And what we'll hear from in a minute from Thomas and Mari are the origins of what I think of as the Western law's response to earth-centeredness, really continuing to try to find these different ways of engaging in caring for the world and caring for country, built on 600 or 2,000 years of a legal system that really does only see nature as property. So that's enough from me. Normally I show slides, but we've only got, it's an hour today, and I really want to listen to Thomas and Mari. I will pop some links in the chat for Earth Laws Month. Please do check it out. There's a lot of great events in there that I'm sure many of you would be interested in. But now I'd like to introduce Thomas and Mari. I came across their work many years ago when they had co-founded CELDF. And it's a very long acronym, which I won't try to remember. I should have written it down. But the pioneering work that I was reading about, where in the early 2000s, Thomas and Mari were engaging with communities and helping communities really challenge the very foundations of a legal system that was overriding their interests and destroying the planet. But I'll now hand over to Thomas and Mari to let them tell you their story about what they've been working on. So Thomas, Linzey and Mari, Margil, I'll let you organise yourselves however you wish, but thank you so much for joining us.
Great, thank you, Michelle. And just at the outset, big thank you to AELA and Michelle. We're big fans from here, and big thank you to having us for Earth Laws Month as well. So the first part of what we're going to be talking about, if it was titled as a movie, would be the rights of nature, the formative years. So I'm going to talk about the beginnings of the rights of nature movement in the US and basically answer the question, you know, why rights of nature? Why did it arise in the United States when it did? And what are rights of nature? What does that mean when we use the phrase? Well, what it means is recognizing human civil rights type protections for ecosystems and nature. And I'll say it again, recognizing human civil rights type protections for ecosystems and nature. And I don't think we'd be talking about rights of nature at this point if we had an environmental law system that actually functioned. that was actually working. But and we certainly don't have to tell folks here on the call what the state of the environment is today. But just in the US, for example, we release 4 billion pounds of toxic chemicals in the US each year legally through a permitted process through our national environmental laws. 80,000 industrial chemicals are currently in use here in the US, and 700 can now be found in every human body. Half of all plant and animal species have gone extinct in the US. 90% of all original forests are gone here in the States, and 40% of our waterways still fail to meet even the minimum clean water standards like fishable and swimmable. Those are some of the standards in our federal clean water laws. So something isn't working. And when we even talking about the elephant in the room, which is climate change, even the most pessimistic projections of the climatologists at this point have proven to be downright optimistic in terms of what we're seeing on the climate change front. So we've all come to different conclusions about the state of the environment and where we sit in terms of what we should do next. And we all have different journeys. My journey was as a conventional environmental lawyer for a decade, trying to enforce the Clean Air Act and the Clean Water Act in the US and the National Environmental Policy Act. The joke we always make is if it had an acronym, we tried to enforce it for 10 years. And at the end of that kind of period of time for us, we came to certain very hard truths. And one of those truths was that we were essentially trying to enforce regulations, environmental regulations against corporations and industries when it was those very industries and corporations that were writing the regulations in the first place that we were attempting to enforce. And then we were acting surprised when we couldn't actually stop something using the regulations that the industry itself wrote. And this is no different than in Australia or the other countries where we work, which is the fact that major industries write the regulations and environmentalists come in and try to enforce those. And then we act surprised when we actually don't win under that regulatory structure. And two things hit me during those 10 years of doing that kind of work. One was that the monies that the corporations would spend defending their permit issuances for a particular project were actually tax deductible under US law. But the same monies weren't tax deductible for the community groups or the citizens who we were representing to actually fight those permits in the first place. So part of it is structural. And the second thing that someone said back then that really resonated with me is she said the only thing environmental regulations regulate are environmentalists, that they make us predictable when we defend against a specific project because we're using the very regulations and regulatory defenses that were written by the very industries that we were attempting to hold these regulations against. So after about 10 years, we quit doing that work. But there's an even more basic problem about why environmental laws don't work. And Michelle raised it in her intro, which is that nature under our Western system of law, our European system of law, is a thing. It is property, mere property under the system of law. It's actually treated as a dead thing, an inanimate object. And that's, of course, much different than how indigenous cultures see nature. Indigenous cultures speak about, for example, the Chippewa in the States, in the state of Minnesota, talk about the swimming people and the singing people, the birds and the fish. They talk about nature as being animated as a relative. So the Yurok in Northern California in the States talk about the Klamath River as being a living relative, a relative of the Yurok people. And so there's a much different language that gets talked and value system from indigenous cultures than this Western system. So animated and alive versus what Sir Francis Bacon, there's a quote usually attributed to him when he said that the goal of Western civilization was to torture nature on a rack to extract her secrets. So I don't think we need to be, advanced literature kind of majors to understand the difference between torturing nature on a medieval torture instrument to extract her secrets versus talking about the singing people and the swimming people and the way indigenous cultures speak about nature. And the difference makes all the difference in the world because in Western cultures and this Western system of law that we have, that property, that nature as property, property is protected by the highest system of rights in these countries. So in the US, we have a US constitutional system that protects property rights above everything else. So we scratch our heads and we say to ourselves, oh my God, how can this be that we can't protect nature the way we want to? Well, we have a system that's baked in. It's the DNA, it's a source code about how property is protected above all else, property rights, and that we can't pass laws or do any kind of enforcement actually runs up against that property rights kind of framework. So the question we get often is kind of, so what? We have this system, what do we do about it? Well, you know, we're not the brain surgeons that kind of came up with rights of nature. It was back in the 1970s in the States when a university law professor named Christopher Stone wrote an article called Should Trees Have Standing?, which basically argued that trees and forests and valleys and other ecosystems should have the ability to bring a case in court as a plaintiff. We think about plaintiffs as being people or groups, but Christopher Stone was asserted this proposition that nature should be able to come into court as a plaintiff. And that article would have probably not gone anywhere, except that it was picked up by a Supreme Court justice in a case dealing with the Disney Corporation's plans to put in a ski resort in Eastern California. And Justice William Douglas, who was one of the most progressive environmental justices on the US Supreme Court that we've ever had, used that article in a dissenting opinion in this case called Sierra Club versus Morton. Name isn't really important, but used it to say that ecosystems or nature should actually have rights, not only actually have standing to be in court as a plaintiff, but actually have substantive rights against development or other activities that would adversely impact those ecosystems. So then people ask the question, well, what happened? That was 1972. What happened next? And the answer is nothing. Nothing happened until 2006, when a frustrated lawyer was approached by a municipal client, a small city in the States, in the state of Pennsylvania, who came to us because they had a project that was being proposed by the state of Pennsylvania to take PCB-laden dredge from the Delaware River and dump it into open mine pits in this little community called Tamaqua Borough, just northwest of Philadelphia. It's a community of about 7,000 people. And they came to us and they said to us, we don't want to be a toilet or a dumping ground for polychlorinated biphenyls embedded in this sludge. Can you help us write a law, a local law, legislative law, that would stop that from happening? So we assisted them in drafting an ordinance, a local law that could be passed by that municipality that would ban that kind of toxic material from being dumped into the municipality. And then folks in the community came to us and said, well, that's great. We passed this and hopefully it has legs and everything else. But what about if the project does come in and then pollutes a river? And Tamaqua Borough was home to 2 waterways that provide most of Philadelphia's drinking water supply. So you had trout fishermen, you had environmentalists, you had just people who lived in the community who loved the cleanliness of the rivers, who said to us, well, we need to protect the people here, but how do we protect the ecosystem and the waterways themselves? And we said, well, back in the 70s, there was this law review article that was done and a Supreme Court opinion that was written about this concept, but it hasn't really gone anywhere yet. And they said, well, what would that look like if we did that here? And we said, well, we'll draft something up for you to take a look at. And what we drafted was I had the privilege of working and drafting on the first rights of nature law to be adopted in the world, which was this little community in Pennsylvania who eventually passed an ordinance, I think to everybody's surprise, which recognized the waterways themselves as having rights. So not just people in the community having rights or the democratic authority to ban this PCB-laden dredge from coming in, but actually the waterways themselves having the rights to exist, flourish, and naturally evolve. So think about kind of constitutionally based standards that were premised on rights, and then including a provision in there because we never have any hope. We have hope, but what we're kind of pessimistic about municipal governments actually enforcing these things aggressively. So we built in a third-party enforcement mechanism so that any resident of the community could actually come in and bring a legal action in the shoes of the ecosystem. So in the name of the river, in the name of the stream, in the name of the waterway, as a plaintiff, kind of as a guardian or trustee of that ecosystem that had rights under that Tamaqua Borough law. And then we wrote in a section dealing with the ability of courts to actually grant injunctive relief, monetary damages in the amount of the damage actually caused the ecosystem. Those types of things built into this Tamaqua ordinance, which you'll see today in a lot of the rights of nature laws that have been passed around the world, kind of the same kind of concepts. These three pieces of rights, who can sue over those rights, and then what kind of remedy can be awarded by a court in terms of hearing those rights. And so I think Tamaqua Borough got people kind of thinking about the possibility of doing this at a local level, because most times we can't control what happens at the state or the federal level. We don't have as much control there, but at the municipal level in the states, seemed to be that was a kind of strategic lever to move into that space to be able to work with those municipal officials to pass those kinds of laws. And what happened next, I think, was even more extraordinary, which was we got a call from Ecuador, and Ecuador was writing a new constitution, national constitution. They had heard what happened in Tamaqua, and Mari is going to take us through Ecuador and then some of the expansion of these laws at the international level. Mari.
Thank you, Thomas. And just to say thanks so much to Michelle and to AELA for having us be part of this Earth Laws Month, which is so great. And as I said to Michelle when we first got on to the Zoom, that we were a little overwhelmed by her calendar because it was just an amazing number of events, and we're really happy to be able to contribute. So I want to pick up from where Thomas left off. So we have those first community in the United States, the first law in the world to recognize the rights of nature. And then the Ecuador constitutional drafting process began in 2007. And in 2008, we went to Ecuador and met with delegates to their, what they call a constitutional convention or constituent assembly. And it was really a remarkable experience. And we were able to help them develop their constitutional provisions, a whole new chapter of their constitution, which for the first time enshrines constitutional rights of the natural world, or what they would call Pachamama, within their constitutional framework. And Ecuador is the only country to have done that, and the first country to have done that. And it was, you know, it's a kind of remarkable thing that they did. And they did it in part as part of this idea that they have what they would call like summa causa, this idea that of community, of good living, buen vivir, this idea that we're all part of community, you, me, everyone in our communities, but that our communities also include nature. And so I think really for the first time, their written laws were demonstrating, reflecting that concept. And for many, it's a very ancient concept of indigenous peoples, First Nations, tribal nations, Aboriginal peoples that we work with in different parts of the world. This concept is very old, that nature, Mother Nature, is a relative, and that we are part of nature and depend on nature. But as Thomas explained, you know, our Western legal systems don't reflect that. Ecuador became the first, it's a Spanish system of law, but it became the first to recognize that Mother Nature, Pachamama, possesses legal rights, rights to exist, rights to thrive, to regenerate, to evolve, to perform its natural functions, like as an ecosystem or species, a right to be restored. And courts, up to their highest court, the Constitutional Court in Ecuador, have not only upheld those rights and affirmed that they exist, but also that if they are violated, things need to happen to rectify that, or activities need to be prevented to ensure that those rights are not violated. One example of that you may have heard of is a case that the Constitutional Court ruled on end of 2021, last year, called the Los Cedros case regarding a protected forest in Ecuador, where mining exploration was beginning to happen. Community brought a case to court to try to stop that, to protect the rights of nature, saying that mining in a protected forest, which is a fragile ecosystem that provides habitat to at-risk species, that mining in that kind of a place would violate the rights of the ecosystem, violate the rights of the species. And ultimately the court agreed and said this would be a violation of the rights of nature and prohibited mining from occurring in that protected forest. And if you're at all familiar with Ecuador or many Latin American countries, they're very economically dependent on extraction and exploitation through mining and drilling and so on. That was a landmark case for their constitutional court to rule on, essentially elevating the rights of nature and the protection and guarantee of those rights above the rights of mining corporations to extract and drill and so on. So the rights of nature is, a new area of law, but in Ecuador, where it's been in place for, over 15 years or 10, 15 years now, that it's really setting a higher standard for environmental protection and creating a new kind of orientation or shift in our relationship with the natural world, which we believe is desperately needed, not just in terms of our own personal day-to-day behavior of recycling and composting and limiting our own personal carbon footprints, but also within our most basic structures of law, including our constitutions. And so we're beginning to see that really evolve within Ecuador, particularly because they've had the national law in place the longest of anyone. But once Ecuador's constitution was ratified in 2008, it really was this kind of milestone moment in which a lot of people around the world were watching this process and saying, my goodness, what is possible? This is possible. And I think it really opened up a lot of minds, a lot of ears, a lot of hearts about what is possible as we are facing all these environmental crises around the world. And so since then, there's sort of been this sort of rapid expansion of the rights of nature movement. We're still very much at the beginning, but what's happened, has, sort of taken us by surprise, honestly, and we continue to work in places around the world. And what we've seen since 2008 is Bolivia now has a national rights of Mother Earth law in place. Panama recently passed a rights of nature law, national law. Uganda amended its main environmental law to include the rights of nature. And so that's direct lawmaking by a legislature or parliament. But we've also seen courts in different parts of the world, in Colombia, Bangladesh, India, ruling that certain ecosystems, including rivers, possess legal rights, and that those rights have to be abided by, that they have to be upheld and guaranteed. So we're seeing both lawmaking occur, that we're all familiar with, policy lawmaking, but also courts saying essentially that the existing environmental laws within their countries are not sufficient or adequate to protect these ecosystems that are under threat. And so they've essentially looked beyond their own national boundaries to bring in the rights of nature and declare that certain rivers, for instance, like the Atrato River in Colombia, possesses legal rights to protection. And so we're seeing this unfolding of the rights of nature movement in this way. And we've also seen not just at national levels, but at sub-national levels as well, as in Mexico, Brazil, Canada, local communities, states, beginning to recognize the rights of nature, particular ecosystems, or nature sort of on the whole, all of nature within their jurisdiction. In Canada, we had the Innu Indigenous Council, as well as a non-Indigenous community, both recognize rights of the Magpie River in Quebec. It's really the first time that we've seen Indigenous and non-Indigenous communities working together in that way. And I think it really provides a nice model for what is potentially possible. We have now over 30 communities in the United States that have established and put in place the rights of nature. And those local laws, beginning with Tamaqua, as Thomas described, those local laws have not only established the rights of nature, but also prohibited certain activities like fracking, for instance, which would be an automatic violation of the rights of nature. So, banning that within the community in order to protect the rights of nature. And we've had First Nations, I mentioned the Innu Council in Canada, but also in the United States. Tribal nations, as we call them, have passed policies, resolutions, laws, for the first time recognizing within tribal governance the rights of nature. And that includes, for instance, the White Earth Nation in the state of Minnesota in the north central part of the country, recognizing the rights of wild rice, or what they would call Menomin, which is a culturally and historically important to them, but also is a really important part of their food and diet. And so recognizing that wild rice possesses legal rights, including rights, not only sort of those basic rights to exist, to thrive, to regenerate, to be restored, but also the right to freshwater habitat, which it absolutely needs to be able to even exist. So expanding legal rights to not only that basic right to exist and hopefully, do better than that by thriving, but also moving beyond that to recognize specific rights that a particular ecosystem or species needs in order to be healthy, in order to be robust and resilient. And so that's one of the kind of evolutions that we're seeing within the rights of nature movement, is moving beyond recognizing nature on the whole to recognizing rights of particular species and ecosystems, but also moving beyond sort of this basic core set of rights to exist, thrive, regenerate, be restored, to recognizing specific rights that particular aspects of nature need in order to have health and well-being. So those are some of the sort of themes that we're beginning to see coming out of the rights of nature movement. And I think it's really interesting to see how it's developed from local levels, grassroots levels, on up to national levels, and as well in Australia, where we've been partnering with Michelle and AELA for a number of years. And her work there has been really significant in moving this forward in Australia. We helped to draft the first state level legislation, which was introduced into Western Australia. And you may have heard of the Blue Mountain Council in New South Wales, where Michelle has been working with the community there for quite some time. And they've introduced, I think it's called the Mayoral Minute, and then a motion on rights of nature, and now beginning to really explore what does it mean for us as a community to uphold and guarantee these rights within our community. What sort of changes do we need to make to our own operations to ensure that we're not violating those rights, and beyond not violating, but also upholding and guaranteeing them. A real shift in the kinds of decisions that we make as communities, as governments, and even as courts, about how do we really make that shift in terms of how humanity, we govern ourselves through the natural world, which at its root requires us to change how nature itself is treated by law, from being this property, this thing, to actually being recognized as a living entity with legal rights. So there's a lot happening in different parts of the world. We see indigenous peoples, particularly the tribal nations that we're working with in the US, is really beginning to take hold of this and really actively become leaders in this field, which we think is a proper place. Because as I said, this is really an ancient idea that we treat as new, sort of Western cultures, but it's really something that I think, especially in our experience, that the different indigenous peoples that we worked in different parts of the world see this very much in keeping with their cultural, historical, and ongoing relationship with nature. So I'll stop there. And I know Michelle was going to open up for questions and conversation.
Yes.
Thank you.
Thank you so much. That was a really fantastic summary of the history and emergence of this really fascinating and fast-moving area of both law and governance. I wonder if we could talk a little bit about some of the details of the different types of laws that are emerging. I know that many of our audiences in the AELA movement are non-lawyers, some are lawyers. And I'd love your thoughts on, I personally was really delighted and surprised when I saw the emergence of a very different approach to law in New Zealand and in Australia. In 2017, when the Whanganui River, everyone started to see the news reports. It started with the beginnings of the Maori discussions under the Treaty of Waitangi, and the news kind of murmured around for about a year or two, and then it was declared that a law had been passed by the New Zealand government that recognised the Maori people's connection to the place, but also recognised the Whanganui River. And this was when rights of nature, for me, moved from an idea of make a law across a jurisdiction, recognising all the rights of nature, and then suddenly the system, which is very different to to some of these aspects of work, where the Maori people, through negotiations, didn't get exactly what they wanted, but they got a halfway place that they can build on, and they've basically, the state decided that the river would have legal personhood. And so I wonder, I'd love your thoughts on, 1 minute we're all looking at rights of nature across a jurisdiction, then suddenly it popped up as an ecosystem rights. And then there was the debate about legal personhood. But did you just want to reflect on sort of some of these differences in any way you wish?
Sure, I can go first. I think what happened in New Zealand is, it's really interesting, and Michelle, you and I have chatted about this before. I didn't mention it in kind of our overview because in New Zealand, they don't talk about it as rights of nature. And I don't mean to put words in their mouths. So I'm careful about that. But since you've opened the door, yes, they were recognized rights of the Whanganui River, of a forest, essentially recognizing them as independent, autonomous entities, living entities, for the first time anywhere in the world. And that's a really extraordinarily important step forward. And as Michelle said, they recognize them as legal persons, which means they have a legal status that nature otherwise doesn't have. And within those laws passed by the New Zealand Parliament, they've created essentially a guardianship in which the indigenous Maori people and the crown government, the central government, together form this guardianship and serve essentially, you could say, on like a committee together to represent the interests of the river or the forest or the other living entities. And so this guardianship kind of approach in which their interests are not their own, but the interests of the river, for instance, is what is the motivating factor for them in the first time. And it's still an evolving sort of process about how that will work. But it actually has, again, like Ecuador, has opened up, I think, a lot of possibilities for people in other parts of the world to say, what's possible? How can we do this? And one of the things that we just like to distinguish between legal personhood, recognition of a river as a legal person, for instance, having a legal status, versus rights of nature is that within the rights of nature laws, particular rights are recognized to a river or an ecosystem or species or nature on the whole. Like we've mentioned, those core, like that basic right to exist, a right to thrive, right to regenerate, right to evolve, right to be restored. The wild rights I mentioned, a right to freshwater habitat. And so those kinds of rights are not recognized in these legal personhood laws as adopted in New Zealand. That doesn't mean that they can't be built in or amended or somehow evolve to those, and perhaps they will, bringing that legal status of nature into a more sort of rights of nature frame, I guess is a way to say it. But I think both of those things are really, really quite important and reflect a real shifting change, I believe, in human relationship with the natural world, to begin to recognize them as something other than just a thing and it that's sitting there to serve humankind. That recognizing that they are living beings that have a right to exist, we need to, sort of get our houses in order to uphold and guarantee those rights. And that can mean changing some of the decisions that we make and some of our behaviors to ensure that we're not interfering or infringing with the health and well-being of those ecosystems.
Yeah, and just to add to that, I think the laws that we draft today are much different than the laws that we drafted back in 2006 to 2010. Even looking at the City of Pittsburgh law, which I drafted back in 2010, what we're drafting today is kind of light years beyond that. Back then it was kind of like, throwing spaghetti at the wall and seeing what'll stick. But it's basically about broadly all ecosystems have rights here in this community. And then, delineating what those rights are and how they can be enforced. Today, we rarely do that work. It's more about a specific ecosystem. A lot of times rivers and waterways seem to be the hot ticket right now for rights of nature. So, the St. Lawrence Seaway, for example, there's a group working in upstate New York in the States on that now. But basically, I think as the work has gotten more serious and people have taken it more seriously, they've invested more time to say, we don't just want to do this general ecosystem thing. We want to focus down on a specific thing like Grass River, or what was on the ballot in 2020, the largest municipality to pass a rights of nature law in Florida, state of Florida. County by an 89% vote voted to recognize rights for the Wakaiba and Econlockhatchee rivers, so two waterways that ran through Orange County, Florida. But focusing down on those distinct ecosystems, trying to pin down what exact rights that particular river has. A right to flow obviously doesn't apply to a forest. So you have ecosystem specific rights, which have been further kind of defined. But the funny thing is it's kind of come back around at some point as well. We've We just wrote a climate ordinance, the kind of a human right, that a right to a healthy climate is a human right, an enforceable human right, that having an atmosphere below 350 CO2 levels is actually a human right. We also wrote rights of nature into that law, that all ecosystems have a right to a healthy climate as well, in addition to humans. So that one's not ecosystem centric, but there's a lot of flexibility to the work, I think. And over the last 10 years, it's moved more in a direction of specific ecosystems. But then as each new issue comes up and we're asked to draft stuff, it kind of returns back around to that more broader view as well.
Thank you, Thomas. Really terrific insights to hear you talking about what it was like to draft in the early days. I love that, throwing spaghetti at the wall. That's in a way what we did with the Western Australian draft law. You know, we drew on what other folks had done. We knew that it wouldn't get passed, but we wanted to raise it as a topic for discussion. And very rarely in Australia do you meet a politician who's keen to stand up and actually advocate for something quite different. So, but it did feel like we were just throwing things at a wall to go, look at this issue, can't we do better? So we've got a couple of questions from folks, but what I'll do is we'll go through a couple, but I might actually come back to this issue of lawmaking for particular ecosystems versus across a jurisdiction, because there's a couple of questions linked to that already. So we might discuss that as a group of questions, but questions that are not related to that. There's one about movement building, an excellent question from Alice. Hello, Alice. Alice is a scholar on rights of nature and a really important contributor to the movement and discussion in Australia. She says, thank you for the presentation. My question relates to movement building. Initiatives like rights of nature that seek to change fundamental norms often involve many different organizations working in different ways or with different priorities. Could you reflect a bit on how this movement has developed in the US and the various roles and interactions of groups such as CELDF, your group CDER, Movement Rights, Earth Law Centre and others? Could you share your thoughts about how the movement has evolved and is evolving, challenges and opportunities? A big question. Thank you, Alice.
I'll take first shot at that. So there's a lot of overlap between some groups, with an understanding that all the groups currently operating in the States, at least, are very small in terms of, when you're looking at the major environmental groups in the United States, you're talking, $100 million budgets. For these groups, a lot smaller, more boutique. And each group has really carved out a niche. So like the Earth Law Center, for example, it's put out a textbook and does mostly educational stuff around rights of nature, some activism, but mostly, how do we build a bigger literate audience or constituency around rights of nature kind of stuff. Our work primarily, as of late, is focused on indigenous communities. We think that Western courts are generally hostile to rights of nature concepts. And we've run into that buzzsaw ourselves over the past 10 years or so. And we think tribal courts are really kind of the next big frontier. Indigenous courts that are controlled by the tribes at the tribal level here in the States. So that's kind of our particular kind of niche at this point, that nobody else is working on those enforcement cases in the States except for us and those tribal courts. So it's a little bit of different, geographic focus for a lot of those groups, as well as some overlap on just basic, moving rights of nature forward as a concept.
Mari, are we going to make any further comments? No? I guess thank you very much, Thomas. My only contribution or my additional comments would be, I've also been sort of watching the emergence of different groups advocating for rights of nature. And so that's what I read about Thomas and Mari's work long before I met them. And it was a delight to bring them to Australia and have those initial conversations back in 2012, 2013. And then when we saw, because this is linked to another question in there. So there's been a lot of different groups popping up, including the Global Alliance for the Rights of Nature. And the three of us were in those early days working on what that global network could look like. And it continues to support the emergence of groups in different regions. A lot of GAN's work focuses very much on South America because the Ecuador and Bolivia movement and many other things going on in that area. And from an Australian point of view, Alice, and I'm sure you've seen this, when the New Zealand laws came out for the Whanganui River and the Urewera Forest, we saw a lot of Aussies starting to really engage. It's as if the connection between people and their local ecosystems was much stronger. So there's movements in Europe as well. And I was just talking to a young barrister the other day from Britain, he's an Aussie, and they are apparently trying to weave rights of nature into actual court cases for some jurisdictions that don't have any reference to rights of nature in their laws. And they're trying to weave in ecocide and rights of nature, even though there's no existing legal framework for that. So in terms of the movement, the only other thing I'd say is I actually think it's really healthy to have extreme diversity in this movement now, because when we come to places like Australia, the kinds of approaches and the attitudes to rights in the US or other is very different in Australia. And Mari and I have had many conversations about this. I don't want to put words in the mouth of others, but in my discussions with various Indigenous legal experts and friends here in Australia, they always say, well, rights are well and good, but what about obligations? And this is really interesting, the idea that, and that Mary Graham and others, please do watch their videos and have a look at their work, talk about the relationist ethos and the law of obligation. And Mary and I are, excuse me, actually working on writing what would a law look like if it was about a law of obligation to care for the river, excuse me, that would also refer to rights, but for the framing in Australia and for Indigenous people, it's quite different, but they're all interconnected in terms of speaking for nature. So I say, keep an eye on the movement. There's stuff bubbling up everywhere. I can barely keep up with it. Yeah, the diversity is probably very healthy because we want culturally different approaches to what fits to a place. So thank you. And there's lots of great questions coming in. So I'll come back to our, back up to where we were. Just for those who are interested, I popped in a little link to the Blue Mountain City Council original media release about what we were doing there and what we continue to do very gently and slowly in relationship with Indigenous people there. Zol has asked a really important question. I hope I pronounced your name correctly. She says, my question is, how can those of us who are not lawyers contribute to this important work? I've always felt so overwhelmed by the law aspect. I haven't engaged with rights of nature. I've preferred to leave it up to the lawyers. Thomas and Mari, do you want to talk? It kind of connects to the movement building idea, and I can certainly share some invitations, Zol, to connect to us. But Thomas and Mari, what are you thinking?
Yes, I'll take a first shot. I think Shakespeare might have been right when he said, kill all the lawyers. Because the lawyer, and I am one, but the lawyers are the problem in a lot of places, especially the Western trained ones, which is that they will work endlessly to undermine the passage of these kinds of laws. Their criteria of success in a career is generally how long the municipality has gone without getting sued. And so they're very conservative and they are not your friend. Having said that, the fact is this work is being done mostly by non-lawyers. I mean, in the States, at least, it's done through this thing called Citizen Initiative, which is we can put things on the ballot directly. We don't have to wait for our elected officials to do it at the city, town, village, county level. And so most of the work is done by non-lawyers here. The job of the lawyers is just to make sure that the forms are right and, that give some advice on content. But this stuff, for it to work, has to be run by the non-lawyers because the lawyers are never going to do it. It's just not going to happen. So there are some friendly lawyers, but most are a problem. They're like priests in the system, and their job is to hold on to this conservative, time gone by kind of Western system legal stuff. And so they're not your friends. That's my opinion, at least.
Yeah, I'll just add, Michelle, that and I just put in a training that anyone that's free to join, it's right on our website, that the truth is that these efforts in different places, national, subnational, local, grassroots, they're not being led by lawyers. They're being led just by non-lawyers, human beings, people. And so I think that everyone, I fully understand this idea that it's something that to be left to the lawyers, but the reality is these campaigns are not being led by lawyers. And we have this conversation actually quite often, and to help people just sort of, kind of get over, I think, that sort of mental block, which I fully understand, because as Thomas said, it's the lawyers, that can help catalyze, but they also can construct. But it's really just human beings that are leading this, and mobilizing, because this is really about engaging our communities, engaging our countries even, and helping to educate and advance learnings for people so that you are really creating a movement, whether it's in your very local community or in a larger sort of place. But that's not the work that lawyers do. That's the place that human beings do, and one-on-one and larger conversations. And so the education and learnings, we do so much of our work as workshops, trainings, educational opportunities with non-lawyers, so that people gain an understanding of what this is, but also more importantly, how do they mobilize to make this change wherever it is they live. So please don't be discouraged by it seeming very legal. It's really not about the law so much as about changing the law as much. How do we change humanity? And that takes non-lawyers, believe me.
Thank you, Murray. And I would agree with Thomas's statement, not so much to kill all the lawyers, because I'm a recovering lawyer myself, but the legal system is not our friend when it comes to supporting the environment. It wasn't designed to do that. But our legal system in Australia came over from Britain, from the British Empire, and that legal system was already hundreds of years old in some respects and thousands of years old in terms of patriarchal property laws. So the legal system is part of the problem. And I couldn't say it any better than Thomas and Mari. And I will come, there's another question about, well, how can folks get involved and how can land care groups do things? Can I please encourage you, like genuinely, shoot us an email at AELA. After we survive our Earth Laws Month, we're going to be resuming some really cool community-based work around rights of nature, laws of obligation for place. And both in the Blue Mountains, there's some work that we'll be doing. We've got the Hawkesbury, Nepean River and the Waterkeepers folks. We're having workshops with them in October, and they want to explore with their Aboriginal colleagues the best and most appropriate way to start really advocating for better protection of the river and what that might look like. So if you have an interest in any of it, please shoot us a note. We're going to be building a whole range of community activities, info sharing, etc. So, and I'll put the email address in there. There's a great question from Ian Lowe, and it's lovely to see Ian. Ian is one of Australia's most wonderful treasures. He's a leading natural scientist. Does that make you innatural? A scientist in the natural sciences. And thank you for your question, Ian. Ian is basically asking, do our speakers agree with, or what is your thoughts on the fact that lawmakers don't really want to make these laws, or they'll only do it if it doesn't interfere with their core business of promoting economic growth. Do you want to talk a bit about how you handle this discourse of growth, growth, growth?
Yeah, well, in these campaigns that are run, you have to attack it directly. And I think it's been most effective in places where there have been environmental issues that have resonated with a big portion of the public. So for example, in New Hampshire, one of the campaigns that was run talked about, the need to protect waterways there. And somebody said at one of the meetings, well, this is gonna affect jobs. We're not gonna be able to attract jobs here. And the other person said, well, there ain't gonna be no jobs if there's no water. And so it's like very basic stuff about confronting this concept of endless economic growth as being possible, with or without natural resources that are actually the reason why economic growth is possible at all. So kind of teaching people, learning with them as they crack that argument in very specific ways to get into people's brains. Human brains are funny. I mean, here in the US, like Pavlov's dog, because constitutionally property is protected as sacrosanct. It's covered with constitutional protection. So if you're an elected official and you're doing something to affect property rights or economic growth, you're worried about getting sued, for violating a corporation's constitutional rights by forcing them to abide by these rights of nature laws around a particular waterway, for example. And so it's, you peel back the littlest thing and this big system becomes very clear and apparent, which is why we talk about changing the federal constitution as well as the state constitutions here, because eventually it has to work up. But the only way it works up is if you have the force from below with enough places doing it to actually force that change to happen higher up.
And I'll just add that those arguments about economic growth and jobs, those are not unique arguments against the rights, just against the rights of nature. We see them in the States and elsewhere against any kind of environmental protection that's being proposed.
Okay.
So it's not a new argument. It's just one that we have the need to challenge and take on when it occurs.
And there's a question from JP about cultural norms, which I think you've sort of answered, which is if we want to change cultural norms to think differently about nature or to challenge growth as the be all and end all of a human society's purpose, then it's about conversations, and it's about getting those ideas contagiously infecting, in a good way, people's minds and leaders. And I just wanted to mention a little plug for what AELA has done. How do we engage in economic discussions? Well, AELA helped auspice the New Economy Network Australia 6 years ago, which is building a civil society space to have conversations about what an economy is for and to challenge very, very specifically in place-based ways what a different or new economy could look like that supports First Nations sovereignty and a healthy ecosystem and great jobs for people and a nice life. So we believe that we've taken on the economic conversation directly. And I have to say, thank you, Ian. It was very deliberate. When we started building AELA in 2012, everywhere we went talking about rights of nature, earth laws, earth jurisprudence, everyone was whacking us over the head with the pretend barrier of economics. So from 2013, 2014, we were looking and exploring to find how do we have these economic conversations. And in the end, we had to build our own network to have the kinds of conversations we wanted. So if anyone's out there in Australia, join NINA, please be part of it. And if anyone in other places, get involved or make your own network. NINA rocks. Thanks, JP. We've got a couple of really great questions, and we might use this as a bit of a wrap up because I don't want to freak people out with any of the legal bits and pieces so much, but there's a good question about, well, can you really remind me why environmental law is so different to rights of nature? And I think we can hold that one and include it in our answers. And someone else asked, do you think that the rights of rivers or the river development in New Zealand has inspired so many of these river-oriented laws? I think the short answer is yes, but let's just talk a bit about that. And there was another question about these differences in ecosystem laws versus ecosystem laws. And I had a private question, and it's one I ask a lot. If we continue working on one by one, a river has rights and this river has rights, what happens when two rivers cross? I mean, if we're doing it ecosystem by ecosystem by ecosystem, isn't that going to start perpetuating some of the problems people think rights create, which is competing rights? And this is what Indigenous folks in Australia say. If you see yourself in deep relationship with your place, then there's no competing rights. Human beings just have to follow the template of caring for country. So it muddles with my head a lot thinking about how we take cool ideas, but in the Australian context, it's a very different world. So that's a long-winded 1-minute version of the question is, let's quickly talk together, the three of us, about these different approaches to making law. So first, let's remind folks, and maybe Thomas, this one's for you, how environmental laws work versus how rights of nature or river system laws work. Can you go that one? And then Mari and I will tackle some other ones.
Yeah, we could probably spend 3 hours on that one.
We could.
But the way the environmental laws work are essentially constraints on property. So they're regulatory in nature. And our take on the environmental laws is people think that they actually stop folks from doing certain things. But in reality, the environmental laws operate as permits, basically licenses. They're not called permits for nothing. They permit certain things that might otherwise be illegal. So when a permit gets issued or a license, to dump 50 parts per million of mercury into a waterway, that activity might be illegal under other law, but is now protected by that permit or license that's been issued by the regulatory agency to do that activity. So we try to flip the nickel, flip the thing onto the other side, which is that environmental laws aren't really about prohibiting anything. They're actually about licensing or permitting stuff. And that gets us into a better place to then talk about how the rights of nature laws are different. One way to look at how the rights of nature laws are different is that look at human rights. You may have a law that says, you're prohibited from littering on parkland. But then on the other side, you actually have a constitutional right of some kind, which is flexible, can be interpreted by the courts in different ways, can be expanded out depending on the changes that occur during a particular periods of time. For example, some constitutional rights in the US mean much different things now than they did 60 years ago. And it's very important that they be flexible and expansive enough to actually control that judicial interpretation process. So that's one reason to move outside. Also, the current environmental laws don't really recognize individual people's ability to enforce them. So you're dependent upon government to enforce, but there's no third-party enforcement on real substantive stuff here in the States, at least under our environmental laws. So one of the shifts there is to recognize guardianship or trusteeship to allow individual people to step into the courts on behalf of those ecosystems.
And perhaps just quickly, the other thing to remember is that environmental law still treats nature as an object. And this comes back to one of the questions, like, what's the difference if you've got a national park? So theoretically, a national park is awesome. And most of the time it's well cared for, but it's still just an object. It's still humanity saying, well, all of nature's ours. This one's pretty, we'll keep that bit. This thing's ugly, we'll do whatever. This is flat, we'll use it for ag land. Let's mow down this forest because we can use the land. And it kind of comes back to Ian's question. Economic issues have always been more important. And even if you think chronologically, because I'm a mad historian, environmental law is the poor cousin of property law. Property law is thousands of years old. And in its modern form, those ideas were brought to colonies 500 years ago by European expansion. Environmental law is 40 years old, 50 years old. And so environmental law is literally being tacked on to the side of grow, 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 own, buy, purchase, use, use, use. And the extractivist history of Australia is profound. You know, laws that said, if you don't mow down all this land and do something else to it, we'll take it off you. There were literally positive enforcement of changing the land to show you are using it. And that's why we'll give you this land. So terrible ideas in traditional law. Rights of nature is trying to say, forget all that. We have to change our relationship and make sacred again, protecting the place. And if that means changing human activities, so be it. That's what it's meant to do. But thank you very much for that, Thomas. The final thing, and I know that we're just out of time, I just want to perhaps, Mari and I can chat a bit about, if folks on this call, anyone particularly interested in thinking about how to get involved in rights of nature in Australia or engage in it, to really understand these different chunks of ideas that have emerged over the last 10 years in terms of law. So, Mari, I'm going to give my 2 cents worth. I saw Ecuador and Bolivia as jurisdiction-wide, like across an entire place or country, everything has rights. So when people are challenging certain things, they would look at that. The work you did in the US, a small jurisdiction like a county or whatever, is saying in this place, all of nature has a right to exist and persist. Then we saw the New Zealand stuff break open jurisdiction-wide. So think of a whole, on a map, so all the jurisdiction has rights. New Zealand started these ecosystem by ecosystem rights. But inside that, Mari, do you want to talk about, like, I think New Zealand has legal personhood, but Colombia doesn't. When they did the Atrato River, they did something else. So even inside an ecosystem approach, do you want to just quickly mention, there seems to be a number of different takes on that?
Absolutely. I mean, you don't see the word like personhood in Ecuador's constitution, for instance, and recognizing the Atrato River as possessing these rights. It really was a way for them, because there is no underlying law within Colombia recognizing all of nature or any part of nature as possessing legal rights. But they determined that in order to protect this place, this river ecosystem, that it needed to have rights, that it needed to essentially raise the bar of standard of protection. And now we've had a number of court cases in Colombia protecting different kinds of ecosystems, including the Supreme Court there protecting the Amazonian region within the country. And I did want to, Michelle, you mentioned, there was a question I think about, well, are we concerned about, if we just recognize a river, what happens if another river without rights is, flows through or something of that nature? And, so much of this is based on just reality, sort of the practical reality of, can we protect all of nature, which is clearly the goal, like Ecuador has done, or can we start with protecting this river, which is not a small feat. I mean, that's a huge leap forward. And innovating and changing the law to protect the rights of a particular ecosystem or species. And so different places have made a decision, a practical decision about what is possible for them to achieve, knowing they want to protect all of nature with rights. But what if we start with this species or this river and whatever it might be? and seeing it as a way forward to begin to expand that sphere of legal rights to include different aspects of nature, knowing that the overarching goal is to protect all of nature with these rights. And so I think we have to be as idealistic and optimistic as we want to be. We also have to be practical. What can we achieve? How are we going to do it? And that's, decisions that communities and groups and movements need to make as they see their path and journey forward. So I don't think it interferes with recognizing the rights of all of nature. I think it's actually just a stepping stone to that when we recognize rights of a species or a particular ecosystem. And we should see it as an opportunity to not only do that in the law, but also expand the dialogue and helping more people to understand why this is necessary and how to go about doing it.
Wonderful. And I think that's a brilliant note to end on, folks. The only other thing I'll mention for our Aussie folks is don't forget that also 2017, 2018, the Yarra River was recognised as a living being. It didn't change its legal status, but it was the first time in Australian history, or Western Australian history, that Aboriginal language and Aboriginal values and their role in custodianship across a place was recognised. So the Birrarung Council and the Yarra River have made some really nice steps forward. And later this month, Erin O'Donnell will be joining Mari and several others in our Rights of Nature Symposium, where we're just going to get an update on what's going on. The other thing to note is that people like Anne Polina and others, including I think Erin O'Donnell, have written articles about the rights of ancestral beings. And this is beautiful. It changes it again from just being a river to the connection that Aboriginal people have to their ancestors and the spirit beings inside rivers. And that's just a whole nother area and evolution of rights of nature conversations to say, well, what would it actually look like if we did that here? So, but look, on that note, we're a little over time, but this has been a really fantastic conversation. I knew it would be. Very grateful to you, Thomas and Murray, for your time. Yes, please do, everyone, share little daggy air claps or press the emotion reaction button. Thank you so much for joining us. It's been a really informative session, and I hope that your evening in the US and your day in Australia goes well, everybody.
Thank you, Michelle. Thank you, everyone.
Thanks so much.
Thank you, everyone.
Thanks, Thomas. We'll see you all soon. Bye.